Are you there, CJ?
I am.
Okay, I couldn't find the website and Phaedra wasn't answering. So
All right.
let me start.
Do you want to just start off sharing my screen and then you go ahead and do your spiel?
Yes.
Okay.
So let me get that up again. Sorry, 1 second. Hello and welcome to today's webinar on the 10 top ways to prevent employee lawsuits presented by our sponsor, Heffernan. We're so happy you can join us. My name is Michelle Wilcox and I will be your moderator today and be answering questions you may have during the session. Before we open up the session, let's review a couple of items. All the webinar materials we discuss will be found at www.aspenrmg.com/heffernanwebinars.htm. I will be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. If you have audio difficulties or a telephone line goes dead during the call, hang up and call back again to the number. If all lines go dead, watch the on-screen chat box for the alternative call-in number. Feel free to ask questions or provide feedback by using the chat box during the webinar. If you're using a tablet, you may need to tap the screen for the options bar to appear, and then you can select the appropriate option. We will respond immediately, but we will work your questions or feedback into the presentation. If we can't get to your questions, immediately during the session, we will be online afterwards to respond or may have follow-up in an email. You may also reach us at moderator@AspenRMG for the follow-up 48 hours after the webinar. This is a 1-hour presentation. Questions and comments are very much encouraged throughout the session, and presenters will be answering questions at the end. And lastly, we have a number of webinars upcoming covering a variety of topics, including those listed at the Heffernan website. In addition, we offer the mandatory preventing sexual harassment training in English in 3 sessions a year. With that, let's begin with today's webinar, Top 10 Ways to Prevent Employee Lawsuits. Today's interactive session will be facilitated by CJ Westrick. CJ Westrick has been in human resources management for over 20 years and has worked in companies with 25 to 1,750 employees nationwide. She obtained and continues to recertify her SPHR designation, which stands for Senior Professional in Human Resources, since 2002. CJ started HR Jungle, an HR consulting firm, in 2006, and now works with small to mid-sized companies, providing services ranging from situational assistance to full outsourcing of the company's human resources. While CJ started her HR career in the pharmaceutical and medical device industries, as a consultant, she has gained experience and expertise in numerous industries. With that, go ahead, CJ.
Thank you, Michelle. All right, hold on. Let me get my PowerPoint up and running here. All right. Today we are going to talk about how to present lawsuits, and depending on where you're located, sometimes those lawsuits are a little easier to make claims on than others. But we're going to talk about what we should review, what we should have in writing, figuring out what the government's hot buttons are, and some practices that you can use to help avoid claims. I always like to start with a few little headlines, and because I want you to understand how important this is. IXL Learning was sued by the EEOC, and I got to tell you, the EEOC is very active out there. I get emails every week that show who they've gone after this week, and a lot of times it's multiple emails through the EEOC. Michelle, you might put yourself on mute. And so the IXL Learning had fired someone because they had posted on Glassdoor.com that the company was discriminatory. So the CEO had a quick investigative meeting with the employee. At the same time, security was already closing down their access and stuff like this. So the EEOC felt this was retaliation, that they hadn't really even investigated before they'd already planned the termination. Victoria's Secret, they paid $12 million in a settlement because workers were required to call in on a day scheduled to find out if the work was really needed or if they could stay at home. At the time that this lawsuit came in place, it was settled, so there was no actual court decision. But there has been court decisions since then that I will talk about later. And Supercuts paid $2 million in a settlement on allegations that the managers weren't reimbursed for work done using personal cell phones and vehicles. It kind of depends on where you're at on whether or not you have to think about this, but often courts end up saying that if a company is requiring an employee to use something personal for that convenience, because your other option would be that you buy the phones. So they're figuring one way or another you should be putting out toward that particular item that you need. All right, so we're going to just jump right in with our very first polling question, Michelle. And while she's pulling that up for you to be able to vote on it, I'll go ahead and tell you what the question is. Does your company have an employee handbook? And if yes, has it been updated in the past 2 years? And the polling results are going to either be yes, A, it's going to be it has been updated in the last 2 years, B is yes, but it hasn't been updated in the last 2 years, and C is no, we don't have an employee handbook. Michelle, do you have the polling question up? We may have lost her. I think what I'll do is just move right on then.
Can you not? Okay, I'm sorry.
Oh, I don't know. Was the polling question already up?
Yes, I listed it, but it's not showing up.
And so people aren't able to actually vote, right?
No.
All right, then I'm just going to move right on. So let's talk about employee handbooks. First off, I speak with a lot of clients that have pulled together a handbook in this what I consider to be a hodgepodge method. They either pull in one that they used at a previous company that may not be related with certain policies that apply now to the size of company you are. They pick stuff up off the internet. Even like in California, the California Chamber issues some really nice software to do a handbook, but even they several years ago had realized that they've given people the tool but not the knowledge to actually create a compliant handbook. So it really is important. I would say, have an HR professional or an employment law firm create your handbook. I'm not as big a fan of the law firm version because usually it's not quite as employee friendly, and because their focus is on the compliance and protecting the company. But that's still better than the hodgepodge method. Make sure that it's legally compliant. You really need to review your handbooks at least annually. And, depending on what state you're in, there's some states that don't have, much, if any, state employment laws. So you're really only looking for federal changes. But there's other states like California that's got a ton of them. And they're not just all at the first of the year. So you have to take a look at that. and make sure that you've got everything from, your if there's paid sick leave, what it looks like. And I will say, there's a lot of states doing paid sick leave, so you really need to kind of do um, your homework on that to make sure that you've got your policy correct, because the EOC and other legal entities will use your handbook against you if possible. So you want to make sure it really represents what you're doing, and that's another thing, that there's no disconnect between what your policy says and what your practices are. If you're not practicing what you've got in the handbook, then you need to change your handbook or change a practice to make sure it's compliant if it's not. And then there's, because there's always going to be company specific policies. There's, this big slew of policies we put in handbooks that are meant to protect a company. But then there's others, that talk about stuff that's supposed to be helpful to the employee and written in a way to where it's easy to understand. There's a payroll company that I know about that when an attorney I know ever goes into a client who's using that payroll company and has gotten their handbook, he has someone replace it. And and I've looked at it and it's like, okay, he's right. You can't even tell how much vacation you're getting. That's how generic it is. And so that's what you want to be careful of, that you haven't made it so generic that it doesn't even tell people what your policies are. And that means if it's not something clearly laid out in the handbook, it's like when and how they get vacation or any sick leave or any other of the benefits, then it's up to each manager to try and explain it, which means you're probably going to have mixed messages going on out there. So talk about that. One of the things I've got in my handbooks nowadays is about what happens when someone goes on a leave of absence. I've kind of gotten to the point where now you're going to go on a leave. We want back all the company equipment. If they've got laptops, if they got phones, I want it back. Mostly, there's two reasons. One is if they're going to be out for only a week, then it's not a big deal. But otherwise, a lot of times you've got someone else who needs that equipment to try and keep doing the job. Or I find as often what happens is the person is out much longer than expected. And then you have to, somewhere in there you figure out you need that equipment, and they've been terminated. So a bad message that goes out there when you don't just have a rule that says what we're doing. Same thing if you have health insurance. Only your handbook is going to designate how long you'll keep somebody on your insurance during a leave before you'll move them over to COBRA. There is no law that says here's when they have to move over to COBRA. It's up to what you've put in your handbook that's your policy. So take a look at that and make sure that you're getting those things updated and that every employee has signed off on receiving the latest version, and make sure that receipt has a date on it for the handbook. I've had people, clients ask me to come in and do audits, and I'm looking through files and I'll find like 3 different acknowledgments of receipts of a handbook, and nowhere on there is a date. So I don't know which handbook they got. That's not going to help you if you ever get a claim, because you can't say, oh, they got the 2019 handbook. No, we don't know that they did that. So you want to take a look at all your little things when you put in there, and do you really have the protection you thought you did? And Michelle, do we think we can do a polling question now?
Yes.
All right, let's go for our next polling question. And the question is, does your company provide training for your managers on HR policies and employment law? We got yes, that you regularly do it, yes, when we think of it, and no. If you just go ahead and fill in.
We have 39%, or actually 41% says yes when we think of it, 28% says yes regularly, and 31% says no.
Okay. Training isn't, whoops, I'm going the wrong thing here. Training is let me move screen. Okay. Training is important. I mean, in a lot of companies I do know kind of avoid it or don't do it or think that it happens by osmosis, but it doesn't, believe me. So, what you're really training for, especially if you've got managers, so there's a lot of different kinds of training. Some of it is going to be where you might be subject to OSHA claims, that you haven't been doing your safety program. And every company in California, every single company is a safety program and is subject to OSHA wanting to see it or something. But a lot of companies out there in all states are doing something that's using chemicals or machinery or even hand tools that require a safety protocol. And so if you're not doing training on that, you again are exposing yourself to a lot of risk, because as soon as an accident happens, and I don't know if you've noticed, but OSHA has been getting, let's just say, a lot more fierce in the last couple of years. They're wanting a lot more information from every company, stuff like that. So, take a look at your safety programs. And then when you talk about managers in general, do they know how you want them to supervise their employees? It doesn't happen by osmosis. It happens by however they last got training, or by how they were trained by someone, a different manager, but not necessarily in your company. So you really want to understand, have a manager, because a manager's on the front line a lot of times. It depends on how high up they are, but you need to make sure they understand how your corporate culture works and what you want them to do. And you want them to refer to when I worked inside, we ended up with a rule: no VP ever mentions benefits to an employee. If an applicant or an employee has a question about benefits, they were sent to her, because I've seen too many times where that manager or that VP doesn't really understand the benefits, and they throw it out there. Isn't what we're offering. And we've got a promise by someone in man, and that actually carries in court versus it is. So kind of look through what you're doing with it. And just on disciplinary action, also ever do performance reviews. Different your managers are. I mean, I've had a VP who would give one time. It's like gave our receptionist the highest rating possible, simply because she showed up for work every day. He ignored the fact that we were having issues with her, with drugs and stuff like this. It was like, oh no, but she's got the effort. She's coming there every day. Well, that's not typically your sole reference point when you're doing a review on someone. So you want to make sure they understand. I've gone into clients and just helped do some training before doing performance reviews, so that everybody's kind of on the same page. They know what kind of marks you're looking for, what you're doing, because the worst thing you can have to find out you've got, your managers at really different levels of doing their reviews or raises, stuff like that, to where you have an inequity in the company. And then we've got the harassment. We've all seen, like over a year ago, where the Me Too, and it kind of like started moving a lot of stuff forward. So there's a lot of new. California put a new harassment training law, several new laws for harassment. But we have to have everyone. If you've got a company of 5 or more employees, every single person must go through mandatory harassment training. It's the 2-hour supervisory, if they've got any level of power over other employees or supervisors. And then there's a 1-hour mandatory for the non-supervisory. And we need, even no matter when they last got trained, everybody needs to get trained in 2019, so that it's done by January 1st of next year. So that's what California is doing. But other states also have been, and even the feds are looking at the harassment, because it became such a big deal to realize how widespread it was. I don't think there were a lot of people who really thought it wasn't widespread. It's just that it wasn't as noticeable before. And so there's a lot of new rules out there, and make sure you know what your state is doing, and and the feds, to see what's going on. But unless you train people, they don't have a clue, and they're working off of just their own instinct, which may or may not work out well for the company. And in some lawsuits, I know that managers are now, I know in California, a manager is able to be sued separately for harassment. So it's not just up to the company. And that's another reason that your managers need to know stuff like that if you're in a location that does that. And then we also want to look at due diligence. There's so many times when you realize 6 months into the job that something is seriously wrong with someone that you've hired. And, you're looking at this and thinking, well, why didn't we catch that before? And a lot of times it's because companies aren't doing their due diligence. If you're in a smaller company, you may think that the manager did all the due diligence for you. But until you put a process in place and make sure that it's being followed, you don't have any due diligence. And due diligence actually does help if you get a claim. about something, to where I've seen it go to where 6 months in, you find out that the employee lied on their application. And after all, did not work at these locations or not for the period of time and stuff like that. And so now you're wanting to fire them because, wow, they lied on their application. And a judge actually said, well, that would have worked back in the first 2 or 3 months. But now the person's been there for 6 months, theoretically doing okay. So that's no longer a cause that you can use. And, so the due diligence is important. If you're doing background checks, make sure you do them and make sure you do them in the right timing so that that's not a claim on its own. If you're doing drug screening, California, you can't do random drug screening. And I've had in the last year 2 companies call me after they did it and with questions about the results. And so that makes it interesting because now we're doing major cleanup for damage control because they did something illegal. But feds, even have, rules about this stuff. There's certain positions that you want to do a background check on. I've got some contractor clients where there's certain jobs they go on where they have to have the employees who will be on that job site go through a background check before they'll be allowed on that job site. And, so there's a lot of ways that due diligence comes into play. And there's rules now. It's like if you're a federal contractor, you kind of have already picked up on some of this, but the federal government puts a lot of weight on their contractors. So when they've got a project and they hire some company out there to do it, that company has to follow a lot of answer a lot of questions for the feds and do things in a certain way. Well, that's been slowly, I've been seeing it over the last few years, dripping down. Now those contractors are doing the same thing to their subcontractors. And so there's times now, and it's not just the federal government, there's some state governments that will hold the contractor liable for something wrong that the subcontractor is doing. I've got one client where we're like, okay, now we're going to do, kind of provide a due diligence questionnaire at the front end because they were just doing one at the back end. They're a federal contractor, and they were just doing one at the back end to make sure their subs were doing, paying people properly, had, safety policies in place, things like that. And because these are the things the feds worry about. And we were only doing, they had only been doing one after the project was closing down. But now they're going to start doing one at the beginning to first find out what are your policies in these things. I've got little clients that are working, doing some subcontracting for larger companies that are getting these kinds of questionnaires also. So it is really important that you can actually know what somebody's going to ask. If your company's trying to do anything other than just make and sell a product, recognize that this due diligence is becoming more and more valuable to you as a company. But you do need to look and see what it is. If you're calling references for an applicant when you're hiring, recognize that, unless they really had a brain meltdown or something, they're only providing you the names of people that they know will give good references. So you need to be careful about how you ask your questions to try and pull out other information. One of the things I always like to ask at the end of the call is like, if you had to give me one negative about this person, that you really would like to see fixed, what would it be? In all my years, I've only had one person who said they couldn't come up with something. So it's an eye opener. It's like, well, I suppose if I really had to come up with something, here it is. So, look at what your processes are and figure out how you can do better due diligence, because that's how you're going to help your company stay out of court. Next polling question. Michelle?
I'm here.
Okay. Are your pay stubs able to show a line item called penalty pay? Now, this is kind of a trick question because this is mostly just California that has this, but I think there's a bigger point that I'll make afterwards. And do we have any questions yet from our viewers?
Not so far.
Ooh.
They're commenting the audio is kind of in and out.
Really? Okay.
Yeah.
I should mention I'm in San Diego and we've been raining all week, which is unusual for us because it's like internet it's like, I don't know why, but internet when it gets rainy out goes a little wonko on us sometimes. And
It does. It does. Okay, so 44% said don't know what that is.
Yeah.
33% said no, and 23% said yes.
Okay. So I'm going to guess the yeses are probably California viewers. And just so that those of you that don't understand what it is, in California, we're the only state. We've got, there's a lot of things I could say. We're the only state before I say what I'm going to say, but we are the only state that has these very rigid rules about non-exempt meal breaks and rest breaks. And so if you didn't take, if an employee didn't take their meal break within a time frame or didn't take a full 30 minutes or skipped it completely, the company is obligated to pay them 1 hour of pay each day that happens. And that pay needs to be showing up on a pay stub as penalty pay so you can prove you actually did the legal thing of paying them for that. So that's what penalty pay is. And be very, thankful that the rest of you in other states don't have to deal with something like that because it is a pain. But money is a big thing, and it's going to be one of the primary things that employees come after you for. If they see money out there that they're not getting in some way, they will complain. And whether they complain to you or they take it outside to a government entity or state entity, it's up to them. You can't control that. All you can control is to try to make sure that you are doing things correctly. And so one of the big things that has come up, and I didn't list it specifically on here, but I mentioned it when we were looking at those 3 cases that I mentioned at the beginning of the webinar. And the one about Victoria's Secret that people were saying they were not paid for work time and stuff like this. There was a lawsuit, and I don't remember if it was a Starbucks one, I think, but it was something like a Starbucks, like a coffee place. Well, anyhow, they had this person who was required to lock up at night when they close. And so over a period of, I think it was a year, he tracked his time and figured he was owed $107. He filed a lawsuit, and it ended up going to the Supreme Court. And it became kind of a basis for what they call de minimis time. And so what happened was he said that, well, he has to go to the back room and clock out, and then he has to come to the front of the store, put in the alarm, and then lock the door. And that's the time he figured it took him a few, maybe a minute to do all of that, to walk from the back and then move on because he wasn't done with his responsibilities until the door was locked. Well, the Supreme Court stated that this fell under de minimis, and therefore you could kind of ignore it. California Supreme Court, and this is how, it's been on the books for a long time, so it rolled up the California Supreme Court, and they took a look at our laws and said, well, based on our laws, it appears that you need to pay for every second an employee is working. So the de minimis does not count here in California, only in other states where you can perhaps have that extra minute showing up on the time clock that you don't maybe have to pay for, or that they've done, like the walk from the back room to out the door before they were done with their responsibilities. But in California, because we're such a stickler getting every little penny to the employee, you have to pay for stuff like that. And so make sure, and I have seen court cases where rounding up to 15 minutes has actually been okay with the court, but periodically you still have to go in and double check it because they want to make sure it's fair. If any of your tests on rounding, I don't care if you're doing the 6 minute, the 1/10 of, that 10th of an hour, or what is it? They do 6 minutes, 10 minutes, and 15 seem to be the primary breaks for rounding. But you want to go in like at least a couple of times a year and do some tests. Go back through the payroll records and see, okay, because if it shows that the company came out ahead over like a 6-month period, you're in trouble. Because the rounding is supposed to look like it's pretty fair. It may not look fair on a week-to-week basis, but when you do the overall over long term, it needs to look fair. That the difference is very slight between who came out ahead. And other things to consider paying for is like that other lawsuit I mentioned, is the employee's cell phone use. This came out not from a law, but from a court case, to where, again, if you are benefiting in any way from using something personal of the employees, whether it's their car, whether it's their cell phone, you should be paying something toward it. The court case came out to where it was even with a paid plan where it was unlimited use, so it wasn't actually costing the employee anymore. But the court said, doesn't matter. You're still getting a benefit by them using that phone. And therefore, you needed to pay something toward that. So kind of take a look at these things, whether you've got them running around in a personal car. Are you paying the IRS mileage, which is about the only way you can get away without saying it's costing the employee something? Are you paying them for personal use of their cell phone or a laptop? That kind of stuff. And,
CJ, there's
yeah.
there's a couple questions. I'm sorry to interrupt you, but one of the attendees is calling from Texas and wants to know how long must you keep an employee on employer-provided health care while employees out on workers' comp?
There is no rule. You could just say as soon as they stop working. So that's why I said it needs to be in your handbook. I typically kind of run most of my clients, we've got them anywhere from 30 to 90 days, and realize that 30 to 90 days is kind of a moving target because insurance will always run to the end of the month for the employee. So you're really counting from the time it would stop. So it's like, okay, we'll let it go an extra 30 days, but that is also dependent on them making their copays if there is one, because as soon as they stop their copays, no matter how much time you've said you've given them, then that can shut it down and move them over to Cobra. Hopefully that helped answer that. And
Gotcha.
so
Stacy has a question asking, is penalty pay for hourly employees only?
yes. And even in California, if you're on an exempt employee, they kind of don't care if you ever eat or sleep. And so it's only the hourly employees that they are very, very picky about. So when you're looking at the money, it's like, double check your paychecks. I've gone in and done audits with companies, and usually the first thing I'll look at is I'll ask for a pay stub because I want to take a look at it. It's supposed to be very easy to read. I had one client that had two problems immediately. One is they were doing like a semi-monthly payroll, but the pay date was like the one for the 1st to the 15th was actually they were paying on the 1st of the next month, which based on California law for payroll was one day too late. And well, actually, it was more than that. It was like, what were they doing? Anyhow, they were paying it, whatever it was one day too late, but it only was on months with 31 days in the month. So it was kind of this weird little thing that they had set up, and this was a company with like 150 employees, so it wasn't a tiny company. They didn't know better. They even had a separate payroll person, but he hadn't bothered to check in a long time. So you need to go in periodically and check, because let's face it, even the payroll companies out there, the providers, they get these little burps every so often. I know of a company that that was using a PEO. They'd moved to a PEO, and the PEO, which is if you don't know what a PEO is, it's a professional employer organization. And they kind of will take over doing a lot of the admin stuff, or, like they'll do payroll and workers' comp and health insurance and other things in there that they offer up. But the PEO, it turned out, had not checked their records either to see that this company was having their payroll come out, and it took 6 years before it popped up. But suddenly they're in the middle of a lawsuit, so that company is getting sued by clients or by employees, and then that company is suing the PEO basically to have them pay for it instead, because they were the ones that should have been looking at this. So but I've talked to a lot of employment law attorneys who are running cases, and there was one with a $2 million lawsuit against one of her clients, that because somehow think about this, there's a company who's had the same name, same location for 40 years. And yet sometime it was like 3 years ago, suddenly their pay stubs dropped one of the words out of their company name and dropped the city they were located in. No rhyme or reason to it, but they ended up with a $2 million lawsuit because of this. And I'm not sure about other states, but in California, their only recourse was, and you only had like 32 days to do it, to go back and replace every single pay stub for the 2-year period that was involved. And they had like 250 employees. So we're talking a whole lot of pay stubs in a very short period of time. So word to the wise, keep looking at these things. Don't assume technology will solve all your issues because it will not. Um, and to take a look at the stuff you've got in place. Make sure, because the money is always going to be a huge hot button for the employees. And the states are usually more than happy to help them get the money back. Moving on to another polling question, Michelle. So this one's come up a lot, especially in California in the last year. Do you know how to determine between an independent contractor and an employee? And
we had another question. Somebody wanted to know if they have an employee that works at home, are they using their own PC or uses their own personal PC and data line? Do we need to reimburse them?
You should reimburse them. You should reimburse them something, because technically, if you're allowing a person to work remotely, you are responsible for providing them with any office equipment they need, and any, if they had to upgrade their internet service to accommodate your needs, then at the very least, that should be covered, stuff like that. I've got one client who will actually ask the employee to take a picture of their office space to try and help avoid workers' comp claims, because even if in a home office, you could have a workers' comp claim because they've got such, they either don't have a true office desk, set up, and so they're screwing, messing up their back a little bit, or they're tripping over a cord that they left laying around. So it is, the remote workers are not just carefree for you. You need to at least take some steps and do a little due diligence on it and look at what you're providing them to do the job. And
in answer to the polling question, 96% said yes, they do know what an independent contractor. 4% said no.
All right. So, there's always going to be lawsuits about exempt versus non-exempt, employee versus independent contractor. And with exempt versus non-exempt, it's in every state. It's going to also look at overtime. California, it's meals, and we've got a daily overtime, which none of you out there have in other states. So that's why I said only in California. But, there are rules. It's like you're still needing to track if you've got managers, sending emails to non-exempt employees in the evening. That's paid time. It's not something you can just ignore. So either make up rules for it or recognize that. But there's a lot of times when I've gotten so many calls now. In most other states, it's a little bit easier to have someone exempt from the salary side, because there is always a minimum salary. But the duties tests are the same nationwide pretty much. So because these are the rules that come down. And so you have to take a look at that and make sure that this person truly has the level of responsibility to qualify as exempt. Because if you ever get a claim and some exempt person says, I've been looking at this and talking to people, and I don't think I should have been an exempt employee. So now you're stuck. I know, at least in California, I've actually handed someone 4 years of calendars and say, okay, why don't you mark down here all the time you think you spent overtime or extra time outside of a 40-hour week? Because now we're going to have to take the employee's word and pay them for that time unless we can prove otherwise. And usually an exempt employee is not maintaining a time card. So that's one of the big challenges on getting it right. Nobody cares if someone's non-exempt. I mean, that's a give, that's where you start. You have to prove that someone is qualified and meets the qualifications of an exempt employee. Employee versus independent contractor, I've seen this flip from the federal side and from the state side, where the person working for you as an independent contractor, let's put it this way, that contract means very, very little. It's a piece of paper that helps, and you definitely want it, but it is not going to be the deciding factor. California Supreme Court this last year came down with some rules. We've always had this like 20-piece test to do, but now it's down to kind of 3 basics. How much control do you have? Are they doing something that's not part of your normal business operations? And do they truly have a business set up with other clients? And California Supreme Court said if they don't meet all 3 of these ABC tests that they came up with, they are an employee, flat. simple. They have to pass all three of those tests. So the bar got raised a lot. I mean, there was a big march in Sacramento about this because a lot of contractors wanted to stay contractors. But, and I've told companies before, it's like if you've got a bookkeeping service, but all of your bookkeepers are independent contractors in California, they would be employees, and you would be subject to having misclassified them. So, and I've seen where somebody signed an agreement, did the work, but when tax time came around, because that's when it really hits it for them, one for a biotech, a scientist that they had used as a contractor for a few months to do something special, ended up turning him into IRS saying, I think I should have been an employee. And because I think she just didn't want to pay the taxes on the $43,000 she'd been paid. So, it's like, and the thing to always keep in remember is that as far as I've seen, there is no state or even the federal government that will hold the contractor liable. It will always come down to the company having misclassified them, and the company gets hit with the fines and penalties. Never, ever the contractor. So you can't leave it up to the contractor to decide for you. You need to make that decision in order to avoid misclassifying and ending up with a claim. All right, another polling question. Do you have a written sick leave policy that meets your local and or state law?
So one person asked while we're looking at these, one person had a question saying, we pay semi-monthly for exempt payroll, 1st and the 15th each month. What is the law regarding missing days of work? Can I deduct hours if it's a personal day and not sick or vacation?
Is that an exempt employee?
They didn't specify.
Well, because I would assume, yeah, it's like, but yes, even with an exempt, you could deduct if out for the whole day for a personal day. Typically, it kind of melds together with what your time off policies are. So I can't just answer it blindly by saying absolutely yes.
Right. So the polling question is 82% says yes, 10% says no, and 8% says we have PTO and don't need it.
All right. So there's been a lot of confusion over the sick leave, and I've been seeing more and more states including paid sick leave now in their laws. And so you really want to get some clarity on this. When California first came out with theirs, like 3.5 years ago, a whole bunch of confusion. Even the attorneys were confused originally because it was a badly written. And so we were kind of waiting for somehow to learn exactly what it was we needed to do. It took the state 6 months to kind of come out with, oh, but you could do this or that. But anyhow, you need to take a look at it. In California, we have a state law, but there are at last 29 different versions locally. There's a city of San Diego law. There's different Los Angeles. I mean, just take it all the way up and down the coast. There's 29 different sick leave laws that are laws. And so you have to judge, I've got a lot of clients with field employees. First thing I'm going to ask is, like, they're in San Diego County and they're like, oh no, we're over in this town over here in the county. Like, well, are your people ever in San Diego? And it's like, yeah, we got a lot of jobs over there. It's like, all right, then when they're in San Diego, you've got to meet San Diego's rules. And a lot of the sick laws also have combined a different minimum wage than the state minimum wage. So that's another thing to look at, is that they're packed together. Like the city of San Diego law is a combination minimum wage and sick leave that's special higher than the states. And so, we've got California that has a law. We've got District of Columbia, Connecticut, Massachusetts, Oregon, Vermont, Arizona, Washington, Rhode Island, Maryland, New Jersey, and Michigan that I know have state laws. But even outside of those states, New York City, Philadelphia, Minneapolis, Chicago, Austin, Texas, they have city laws. So make sure you're looking carefully at what you might be subject to. I mean, in California, we've got so many, I've had to keep a chart up in my office, which is so sad. But, and if you do a PTO, which is a combination sick leave and vacation, you need to make sure your PTO meets the requirements of the sick leave law. Now, where I usually see it falling apart is they don't start PTO from date of hire, which you must do in most of the sick leave laws. And there's a what the sick leave laws have called a fast accrual. So it's a higher accrual rate. And my experience is that unless you're offering at least 2 weeks of PTO, accruing 2 weeks of PTO from date of hire, you're not going to be meeting the sick leave laws. So double check
Yeah.
your PTO policy that it does
So
combine.
I'm sorry to interrupt, CJ, but Catherine is asking, where do we find out which county sick laws apply to our districts?
You can actually just look it up online because they all seem to have posted something like a flyer or whatnot online that you can access. So try that first. Just kind of, it's like here I would just say, San Diego sick leave law. Now that doesn't say county or city, but the city one would pop up for me. So try that and look and see. Also, check with your state Chamber of Commerce. Ask them if they've got a list. Because I know the California Chamber does. So, but online is where you can find a lot of it. And but so take a look at that and make sure that you are compliant with what it is and put it in writing. I actually had someone tell me that we cannot hold an employee to the limit that we wanted to unless we have a written policy. Verbal won't cut it. They can have pretty much unlimited unless you put it in writing. And a lot of the sick leave laws provide protection for the person calling in sick. So really take a close look at that because that's been huge, a huge mental change for a lot of people. And as more and more states are pulling them in, every state needs to start looking at that. Be aware when people are on leave of absence that you're not taking a negative action. The leaves, which leaves are protected. I'm always careful, to make sure we document it. So, if you've got an employee that goes out on FMLA because you're 50 or more employees and you're subject to it, there's documentation you have to give an employee within 5 days anyhow, so that starts it off. But what about the companies under 50 that don't have to deal with the FMLA paperwork? Well, there's other stuff now. California this last year put in a new parent leave, so it's strictly for baby bonding, and and that hits at 20 employees. And so you have to kind of take a look at that and see, are you subject to some leaves that are protected? If an employee goes on a personal leave, I will make sure they get a letter that says, we are allowing your personal leave based on, the doctor's note that says you need this much time, but this is not a protected leave. And, so I want it up front because sometimes those personal leaves get, extended over and over and over again. And suddenly you're like holding on to it because the employee thinks they're protected and they're not. So be very clear when someone goes out. If you don't have time to talk with them before they go out on the leave, then send a certified letter explaining here's all the things that are going to happen so that they understand and that you're tracking it. And let's see, what is my next polling question? Okay, I'm going to do this one. How does your company know what to pay employees? And this is in regards to, like, are they paying fairly? Are they equitable? Things like that. So are you using actual salary surveys? Are you going online and using things like salary.com or glassdoor.com? Or are you just kind of guessing that you're in the vicinity of where you need to be?
It looks like, CJ, 54% say salary surveys, 22% says salary.com, and 29% says we guess.
Pretty common. And so there are federal and some state laws about equal pay, fair pay, and this is a movement because of often, historically women have been paid less for the same job as men. But, and a lot of the laws are saying now it's not just looking at the gender, you're looking at, you really need to focus on the job itself. Last year, California took it to the kind of, we'll call it to the extreme by last year, creating a law that said we can't ask an applicant what they've been making. We have to just, if they ask, we have to just say, well, this job pays between $16 and $18 an hour, because they want us to pay what the job is worth. And I've had this argument over and over again with companies, even when I worked inside and with clients, is that, they'll say, oh, but look, this person's only been making 14, so I could pay him 15, and they think it's a great bump, and I get off for less than I was going to pay. And the biggest problem with that is, aside from the pay equity portion of it, is that so often I find that you end up really in a hard position 6 months or a year down the road, because this person has done a great job. And now something's come up to where it's like, all right, you're either going to lose them for somebody who is paying a fair wage, or you have to give them an equity bump and explain to them why you've cheaped out the last year and didn't pay them what they were worth. So it's like you really do want to find out what the pay is worth, and what that job is. And so you also means you need to look at job descriptions. If you don't have them, you want to look at them and start getting some in place, because that's going to help you, because that's going to say, well, this person needed 2 years of experience in this, and we had to have a college degree in a life science. It has to be stuff that you can justify for anyone in that job. So don't just look at the person currently in it. You want to take a very objective look at it and say, all right, in this position, because what's going to happen, and what's happening a lot I see with the minimum wage going up, particularly in California, minimum wage, regardless of what state you're in, affects the minimum salary you can offer exempt employees or pay exempts. And so as that number moves up in time, your exempt levels move up. And I know with some of my clients, we're saying, okay, this warehouse manager isn't going to be worth $60,000 in 2 years. That's just not what we're going to pay a warehouse manager, period, for the size of our company. So that means that at some point they've got to take that person out of the exempt level and move them back to non-exempt, because they won't meet that. But that's also what they've said in California, is that we're not able to ask what they previously made, because they kind of blamed it on the fact that also a lot of people during the recession and since then have lost positions, higher level positions, because companies just kind of cut them out and eliminated them totally. And so they didn't want someone who had been making $80,000 be thrown out immediately without even talking with them for a $60,000 position, stuff like that. So the bottom line is you need it to be fair across it. And our law in California even went to the place of saying that if you had a warehouse manager that had similar requirements as far as what was needed to get that position, like the college degree or this or that, as did this HR manager over here, then across that line, they should be in a similar range. So, I'm not seeing a lot of companies actually working hard at this so far, and even the attorneys have said when these laws started coming into play, a couple of years ago, that mostly the attorneys will make money on this by suing companies and stuff, but the attorneys will come out much further ahead than the employees. But it is time, it's past time to review your what you're offering when you hire people, how you're doing your merit increases, and what you're doing to get market value. Because I do know salary surveys are the best, because it means other companies have input their information. The online stuff like salary.com, Glassdoor, keep in mind it's employees putting their numbers in there, and they do have a tendency to elevate them. So it may not be always, sometimes you just need to call around and do a sanity check, find some competitors and just say, hey, would you guys be interested in sharing ranges, kind of like for types of positions, to see if we're all in the ballpark, or, maybe someone who's not a direct competitor but has similar types of positions. Then, maybe sometimes I find that they'll give you a little information as long as you're not going after an individual's actual amount. But take a look at that, because again, like I said, money makes people look twice at what they're getting and how to deal with it. Terminate cleanly. I found I get so many clients that procrastinate. Well, we're kind of thinking about it. Don't do it. Okay, we'll schedule for Friday. Then Friday comes. Oh, well, Sam was, one of the people they wanted in the meeting wasn't there on Friday. So we decided to move it to Monday. Monday morning, the employee comes in and says, "Oh, I have a workers' comp claim. I'm pregnant. Oh, I have this." And suddenly they're on a protected basis. And so, if you're if you've got someone who's not doing well, don't procrastinate. Take action. Do a write up with them, do something. And I've even had an attorney who told me that if you're truly thinking about, if you're actually thinking about terminating somebody, email that thought to like one of your other senior managers, to your attorney, to your HR person, because that email will put a timestamp on it. So that if then 2 days later they're filing a claim, it's like, well, we are already kind of moving that direction. We just hadn't talked with the employee yet. So look at that. But a lot of employees don't understand why they're being fired, and that gives them a cause for making things up and trying to think it was unfair. You want to be clear. I always say go for the simplest, shortest, the simplest, most legal answer you can give. Don't throw on the whole truckload of complaints you've got about the person. If you can narrow it down to the fact that, we've had conversations that your attendance is bad, we just can't keep going like that. So we're going to end the relationship. But something, simple that they can grasp and walk away with. But there's no reason to tear them down with 4,000 complaints because you're already terminating them. And be clean with it. Make sure it shouldn't be a surprise. So that means that they should have gotten some advance notice that there's problems. You've had conversations. Hopefully you're doing some documentation, but even if you're not documenting something for the employee, should be documented for your file. So you can say, well, we had conversations on this date and this date and this date, but it never changes. You improve for a week and then it falls back down again. And but take a look at it. Don't drag it out, making them think they've got a chance of negotiating and holding on to the job. Because hopefully by the time you're in that room with them, you have made that decision. And make sure you've got all your right paperwork. That if you have to, like in California, we have to provide a final paycheck during that meeting. Whatever, you make sure that you're doing your paperwork cleanly. I'm going to skip the next polling question. The last one, get the right advice. I've had CEOs tell me, well, I spoke with another CEO and he told me this is how he's doing it, so it must be legal. And it's like, no, it's like, it doesn't matter how many people are doing it. It doesn't qualify it as being legal just because it's popular. So make sure that, the same laws, I don't know how many times I've heard, well, we're in this type of industry, so it's special. We've got other rules. It's like, no, it's like the laws are hitting every single industry pretty much the same. There are a few exceptions out there, but they're not nearly as predominant as business owners believe they are. So make sure that you're getting good advice. That if you're using an outside HR consultant, make sure they know what they're doing. I've seen a lot of HR consultants who are merely consulting in between jobs. Doesn't mean that they're a good consultant. Do they have, like, I went to the trouble of getting my SPHR, and that's like a national test on your body of knowledge, so that it's kind of like getting that CPA if you're, an accountant type of thing. So, it's like make sure they know what they're doing. And if you're talking to an attorney, ideally use an employment law attorney, because I know a lot of business attorneys who will take on a few employment law stuff. And I've actually asked them before if they thought if they were providing their client with everything that they should get. And they're, oh yeah, it's like litigation's all the same. So we just have to look up a few cases. And it's like, to me, that's not strong employment law advice. So depending on your state and how tough your employment laws may be, like in California, you would never want to consider taking employment law advice from a business attorney compared to, because we've got tons of employment law specialists here. But there's other states where employment law is not such a big protected category. So it probably is business attorneys, but make sure you know that and that you've done some diligence on that, and that you kind of have made some effort to try and get that information from a proper source. And right on time, I believe, we are done. So are there additional questions I can answer?
There's actually quite a few questions, CJ. Let's see here. If they take PFL in different times of the year, do I only need to give them one time FLMA form or every time they take a PFL?
The paid family leave in California is it's not, well, yeah, you can take up to 6 weeks, and it's kind of a different animal from the normal FMLA stuff that would require that. I would say you still want to document. I mean, to me, they're still asking for the time off, like it's a new absence. Because I know a lot of paternity leave that happens is that they'll like, okay, I want 2 weeks when the baby's coming. I need 2 weeks, this time, and then they use up the 2 weeks later on. I would run it paperwork wise separately each time. Because if you're counting it against their FMLA, maybe they used FMLA for something else. So you can't just assume that it's all nice and clean, because the paid family leave in California is subject to being eligible for some other leave. I know, for those of you not in California, this is a perfect example of how California screws things up. They called a
Yeah.
supplemental pay plan. I know, it's called paid family leave, but it's not an actual leave. It's supplemental pay the state will give an employee for up to 6 weeks. To use that, to get that supplemental pay, they have to qualify for a leave. So they have to qualify for, the new parent leave, the FMLA, even a personal leave could count. But each of those are separate, because that's what you're giving the employee is that leave. And then they apply to the state for that supplemental pay. So that's one of California's screwy systems that they put together. What else
So
do we have?
Miranda had a similar question. Are we required to offer any kind of leave if they do not qualify for FMLA at all?
There is the new parent leave, so that you would look at that if it's baby bonding. Otherwise, no. If personal leave is strictly up to the company on whether or not you choose to offer it. But do be consistent so that you don't give it to one person who's your favorite employee and the next person who isn't so favorite doesn't get it. So figure out what you want to do as a company and then follow that.
Gotcha. All right. Well, this has been super interesting. And there's a lot of questions that we haven't been able to get to, but um, we will answer the questions in a follow-up email for everybody that didn't get their questions answered. And CJ, I just want to thank you and everybody else for attending the webinar presented by Heffernan. We will send information by email with instructions on how to access a copy of the presentation on our website. Thank you for your time and expertise, CJ. We hope all the attendees found today's webinar to be a valuable use of your time. Be sure to join us on February 5th for Preventing Sexual Harassment. And thank you all and have a safe day.
Thank you, Michelle. Bye.